for a special segment, let's take a trip back in time to the 70s, a time of sex, drugs, and rock and roll. A lot happened in the 70s. It was an era of change.
The 70s is remembered as a time when women's rights, gay rights, and environmental movements were at the forefront of policy.
Not only was policy changing, but problems such as the energy crisis, the Watergate scandal, and the ongoing Vietnam War held the attention of the entire nation.
Along with each crisis and civil rights activism came legal cases that would create a lasting impact on the nation forever, specifically the New York Times Company versus U.S. case.
In order to understand this, let's hear from the man who started it all, Daniel Ellsberg.
Hi Daniel, welcome. Can you explain why you decided to leak the Washington papers, the New York Times, and the Washington Post?
Hello, thank you for having me. Well, I plan to release the information as quickly as possible, as the American people deserve to know what the government was doing. I also thought that the information would help shorten the Vietnam War, as I believe that the war was wrong.
Once the papers were leaked, the United States Justice Department filed lawsuits in federal district courts in both New York and Washington, D.C., seeking injunctions against the publication of further articles.
The government offered no proof that future articles would cause a break in diplomatic relations with any country or a new military conflict would compromise military or intelligence operations.
Then what did the government try and prove?
Well, they tried to prove that the articles would interfere with the State Department's negotiations concerning the war's end and generally embarrass its diplomatic efforts.
The two district courts denied preliminary injunctions, so the government appealed. The D.C. Circuit affirmed the district court's order, but the Second Circuit entered a temporary restraining order and remanded to the district court for further proceedings.
As such, the New York Times successfully petitioned the United States Supreme Court to review the case before judgment in the Second Court. The U.S. also successfully petitioned the court to review the D.C. Circuit judgment. Thus, the Supreme Court consolidated the cases.
Wait, so what did the court say? Who won the case?
Ultimately, this was a major win for the press, as the court ruled there was an unconstitutional use of prior restraint. The Supreme Court ruled in favor of the New York Times, and the grounds that it was a violation of the First Amendment right to prevent them from publishing this content.
Wow, so was this case unanimous?
No, it was a 6-3 majority decision, the per curiam decision, as that any system of prior restraint of expression comes to the court bearing a heavy presumption against its constitutional validity. Dissenting opinions were put forth by Justice Harry Blackmun, Chief Justice Warren Burger, and John Marshall Harlan II.
I would like to now introduce Justice Black to hear one perspective from the concurring majority opinion.
Thank you for allowing me to explain my reasoning for my court decision. When making this decision, I looked towards the essential purpose and the history of the First Amendment. As included in the Bill of Rights, a document created to safeguard the certain freedoms from the government. The press is to serve the governed, not the governed, or the governors. The government's power to censor the press was abolished so that the press would remain forever free from censure from the government. The press was protected so that it could bear the secrets of the government and inform the people. Only a free, unrestrained press can effectively expose deception in the government. I'm also supported in my thinking by my colleague, Justice Douglas, as he concurs with my explanation.
Referencing the Supreme Court case Neer v. Minnesota of 1931, which held that prior restraint on publication violates freedom of press.
Would you mind telling us what prior restraint is for any viewers not familiar in this legal matter?
In regards to First Amendment law, prior restraint refers to government action that prohibits speech or other expressions before the speech happens. This logic became a key precedent for my concurring opinion on this case.
Justice White and I agree that in the absence of governmental checks and balances, the only effective restraint upon executive policy and power is in these two areas may lie in the enlightened citizenry. And an informed critical public opinion, which alone can here protect the values of a democratic government.
Now that we have heard from the majority and their concurring opinions, let's move into the dissenting opinions. Chief Justice Burger, can you explain why you chose to dissent in this situation?
When the imperative of a free and unfettered press comes into collision with another imperative, the effective functioning of a complex modern government, the effects of these actions should be deeply studied in order to understand their societal repercussions. The proceedings occurred too quickly, and given the size of these documents, the court was unable to gather enough information to make a decision.
I, Justice John Marshall Harlan II, dissent with the New York Times and Company versus U.S. case due to how rushed these decisions were made. With all respect, I consider that the court has almost been irresponsibly feverish in dealing with these cases, and I know Justice Blackmun agreed with the faults in the proceedings and the lack of attention towards national security.
Well, then how has this case impacted the press and freedom of speech as we know it? This was a humongous victory for the freedom of the press and provided protection for the press in events such as the Edward Snowden leaks in 2013. All right, well, that's all the time we have for tonight. Thank you so much, and I'll see you in the next one.